Hello everyone, welcome back to the channel. Today we are diving into a topic that may come as a surprise to some employers in Singapore. The employment of foreign domestic helpers and the restrictions on where they can work. In recent years, there have been cases where some Singaporeans have employed domestic helpers to assist not only at home, but also in family-owned businesses or even at relatives' homes. So let's unpack what Singapore law says about this practice, the consequences of non-compliance, and how these rules reflect our society's values. Let's start with the context. Foreign domestic helpers work in Singapore to help Singaporean households manage their domestic needs. Typically, their tasks include cleaning, cooking, taking care of children or elderly family members, and handling household chores. However, in some cases, employers may ask their helpers to work beyond their designated place of employment, which is their home. For example, to help at a relative's home or even assist in family-run food stalls or food businesses. For instance, there have been reported cases of helpers being asked to assist at a hawker stall or help in other non-residential settings. While this may seem like a logical extension of the helper's duties, it's important to remember that the Singapore government has clear regulations about where domestic helpers can work and what tasks they are authorized to perform. Let's look at these laws. The rules around employing foreign domestic helpers in Singapore are strictly governed by the Ministry of Manpower. Here's the key law. Under the Employment of Foreign Manpower Act, foreign domestic helpers are only permitted to work in the household they are registered to serve. This means their duties are limited to the address on their work permit, and they are not allowed to work outside of this designated location, even if it's for the same employer. This prohibition is in place because foreign domestic helpers are brought into Singapore to serve as domestic workers, and the laws define domestic work as tasks performed within the employer's residence. Any duties outside of the home, like working in food stalls or assisting in other businesses, fall outside the legal framework for domestic work. This restriction applies even if the employer owns the business or even if it's a paid role. Foreign domestic helpers are not permitted to work in commercial settings or at any location other than the employer's residence. Additionally, asking them to work for a family member's household, even if it's a relative like a sibling or parent, is also not allowed under current regulations. The Ministry of Manpower takes violations of these restrictions seriously, and there are severe consequences for employers who break the law. Let's break down some of the penalties and legal implications. The first is financial penalties. If an employer is found guilty of deploying their foreign domestic helper illegally, they could face a financial penalty. This can be up to 10,000 Singapore dollars per offence, even if it's a first-time infraction. The penalty increases with repeated offences. Next, imprisonment. A foreign domestic worker can be fined up to 20,000 or jailed for 2 years or both. This shows how seriously the government takes such violations. If an employer is found guilty of such violations, the Ministry of Manpower may revoke the foreign domestic helper's work permit and deport her. The employer could also face a ban on hiring foreign domestic helpers in the future. This is a significant consequence, especially for families who rely on domestic help. For helpers themselves, the consequences can be equally harsh. They could lose their work permit and face repatriation, which impacts their livelihoods and future work opportunities. So why such strict regulations? The intention behind these rules is to safeguard the welfare of foreign domestic helpers. The government recognizes that foreign domestic workers are a vulnerable population who come to Singapore to help support their families back home. By limiting their work to the registered household, the law protects them from being overworked or being exploited by employers who may view them as flexible labor for a range of tasks beyond domestic work. Additionally, helpers aren't trained or insured for work outside the home. For instance, if a domestic worker is working at a hawker stall and gets injured, there could be legal and financial complications as work permits don't cover such employment settings. This regulation helps prevent unnecessary health and safety risks for the helper. Finally, These laws reinforce the idea that Singapore's foreign manpower policies are crafted with an understanding of boundaries and specific purpose. Foreign domestic workers are allowed to work here for particular tasks, and the laws ensure this arrangement remains structured and safe. In summary, Singaporeans who employ foreign domestic helpers should ensure they're only working in the employer's registered residence. Asking them to help out at other locations, including food stalls or even relatives' homes, is a violation of the Employment of Foreign Manpower Act, carrying heavy penalties including fines, imprisonment, and a potential ban on future hiring. By understanding and respecting these boundaries, employers not only stay within the law, but also uphold fair treatment and safety for their helpers. Thanks for watching, and I'll see you next time.